This video is the 14th in a series of 17 videos on the subject of appointing custody evaluators and the appointment of guardians ad litem, or GALs for short, in Utah child custody cases. You do not have to watch all 17 of these videos to benefit from this series. Watch as many or as few as you wish. The purpose of this series is to make the case for the proposition that an interview by the judge is a faster, more accurate, more particular, more reliable, and less expensive form of evidence than what a GAL and/or custody evaluator provides. If a guardian ad litem claims to tell the court what a child said, that violates the rules against hearsay and violates the privilege against the disclosure of attorney-client communications. When I point out to the court that a guardian ad litem's attempts to proffer hearsay statements are such a violation, I am either ignored or told that there is a special exception for guardians ad litem, which is not true. When I try to invoke Utah Rule of Evidence 806 to cross-examine a child on the hearsay statements alleged to have been made by that child, to determine whether what the child is alleged to have said is actually what the child said, I'm either given an emperor's new clothes kind of denial or just ignored. Now you understand that if the judge would question the child directly, there would be no need to cross-examine the child in the first place in 90% of the situations. Likewise, if a judge would question a child directly, there would rarely, if ever, be a need to appoint a guardian ad litem or custody evaluator for the child's benefit either. I do not understand why we have guardians ad litem or custody evaluators serve the purpose of, quote, giving the child a voice, close quote, when the child has his or her own voice already and is perfectly capable of using it, especially in articulating and attempting to advance the child's own best interest by speaking directly and honestly to the court as to the child's experience, observations, concerns, opinions, and desires without the child's words being parsed or filtered or misconstrued by second and third hand intermediaries. We've got to stop acting as though the child whisperer is a thing.